Right, thank you everyone. We'll resume. Mr. McLaughlin, where have you got over the lunch break? Sorry, Mr. McLaughlin, you're on silent. You need to unmute yourself.
Apologies for that, sir. I'll just note that we might lose Ms. Spillane relatively shortly. She's got other matters to attend to, so apologies for that. Mr. Blair will be staying on for the course.
That's okay. This is his last hurrah.
Yes, we're making him work a full day on his last one. We'll just move straight on to noise standards and the SAC.
Yes.
The noise standard referred to in the consent is 6802/1991, and that already imports SACs, and so we don't need the specific line that we requested, so we can leave that as it is.
Okay, thank you. That's helpful.
We can confirm the number of units, and the industrial units are specified within the consent itself. So we've restricted those zones. We can confirm that. We've given some thoughts to the reference to definitions. If
Yes.
we can pull up though that P5 and talk to that.
This is a glass of water, not a gin and tonic, by the way, in case anyone's watching, even though it feels like I need one.
My computer has now frozen.
Who's that?
That was Sandra.
Oh,
You're on silent too.
I am. My computer's just frozen. Won't be a moment. Sorry.
Generally speaking, where we're heading with this is that we agree that we can put those definitions elsewhere in the plan. Probably the most appropriate place for them is within the definition section, which takes it out of the Hampton Downs zone. So we would need to make sure that when those definitions are drafted, they're made specific to this zone, so they don't apply elsewhere. I think that's the only place you can put them. But as we've worked through those, how to work that, we note that minor activities probably don't need to be included within that P5 at all. We're trying to figure out why, or if we remove minor activities from that P5, there would be no consequential effects throughout the rest of the provisions. And so what is the purpose of it being there? What it does is, when Hampton Downs have an event such as a small community gathering or a day-to-day activity, it's suddenly captured by that minor activity requiring a TMP. We're not sure that the amendments made to the TMP provisions suggested by Mr. Cooney earlier actually cover those. And so where you're having small community activities, we're actually requiring a TMP, which doesn't seem quite the intention of where we're going, or the purpose of those amendments we made this afternoon. So that's where we're wanting to work through. Just whether we need minor events within that P5 at all.
Isn't the only consequence of it is that you do a one-off management plan that would apply for all of them, which probably, I'm assuming, already exists?
And if we shadow box that through, that's exactly the point. If we could have one overarching management plan for all minor events that apply, so you don't have to contact council each time you do it, is that what is achieved by the amendments we made earlier? That's just where our team got a little bit.
That was the intention of them.
Yeah.
That was the, I mean, it would be, I suppose it leaves it open to the roading authority to say, nah, they're all different. You know, and I can see, you know, Mr. Swears might want to sweat the detail on some of that stuff. But I think from what he said before, he's amenable to the concept. And I would have thought for something as, I don't know if inconsequential is quite the right word, but why you'd be wanting to have a plan when there's, 700 vehicles an hour on a site like that. I don't know. What's your view on that, NZTA?
It's Robert Squares here. With regard to advising council, if there's temporary traffic management equipment that needs to go onto the road network, then the council would need to be advised. And the whole reason for that is that the traffic management coordinator for the council, when any request comes in to use a particular piece of road for TTM, they identify whether there are other activities there at the same time. Now, I'm guessing that Hampton Downs would have a pretty good idea of what's going on outside their front gate. But I think that need to advise council would still be in there, unless within a generic traffic management plan, Waikato District Council gave Hampton Downs more leeway than they might ordinarily otherwise have.
Yeah, but if the council did that, you wouldn't be bothered. I'm assuming it wouldn't make any difference. I don't
anticipate. Sorry.
No, you carry on.
I was just going to say I don't anticipate a minor event would have any noticeable effect on the state highway network.
Okay, well, I think on that basis, what Mr. McLaughlin says makes some sense. We don't need a definition of minor event. We just have a definition of whatever the next one up in the list is. Medium event.
In that regard, do you anticipate that there would still be traffic management plans for events smaller than medium?
Yes, because they're required. In fact, there's still one required for minor events under rule under the standard, doesn't it? Or is it? No, maybe not. Maybe it doesn't. I don't know. Have to think about that. No, because 26.5 applies for all motorsport and recreation events. And rule P5 wouldn't refer to the classification of events. It would say they are permitted. They're all required to comply with the traffic management standards, and the traffic management standards don't refer to size particularly, or to the smaller ones. But the rules that we've drafted would allow there to be a blanket traffic management plan provided for all of them.
And that's what it actually reads. It says prior to any motorsport and recreation event.
Yes.
So there'll be big and small.
Yeah, so I think the plan still provides, but we don't need a definition of minor.
No.
And the provisions still require a management plan, but common sense would say you've got a minor events traffic management plan, whatever you want to call it, that says anything that's less than a medium event. You guys would sign it off and away we'd go.
But if a minor event isn't specified, how do we distinguish between a day-to-day activity and a minor event?
It would just be the wording, wouldn't it? It'd be the wording up to a certain level.
Can we just focus on that? The day-to-day event, because I note that that's been removed within one of the P5 provisions. Can we go to that? Can we go to the P5?
Is there a risk if you take out minor events from P5 that suddenly you're captured as an activity that's not specified elsewhere, and that actually becomes a really restrictive activity status? So an unintended.
Yeah.
That's a very good point. That's a very good point.
Yeah.
Let's not try and be too cute. It's a definition. You've agreed that you need to do a management plan for them anyway. And anything we change now has probably got a gazillion other unintended consequences. Given that it doesn't matter, can I suggest we not dicker around with it?
Yep. Yeah. No, I appreciate that.
Sorry, team. I've just been having a look back at the notified version of the definitions, and the definitions are already in there for minor event, medium event, major event, and extreme event in relation to the definitions for the motorsport and recreation events, part of the definition chapter. So if they're already defined in the definitions chapter, we could just leave the reference to minor events in this particular chapter.
Ms. Tiaho, on that note, you were talking earlier about an adjoining site that is defined as well in chapter 13, which might be helpful.
And what does it say? It'll only be helpful if we know what it says.
It says, means any other site sharing any length of boundary with the subject site, but does not include a site across a road, a service lane, or private way unless specifically stated in the context.
Mm.
Well, that seems what we're after, doesn't it?
Yeah.
Is that the definition? Is your thought that that's an appropriate definition and that's the word we should use?
It seems like a sensible starting point, considering that when you were talking about the rural environment and you didn't want to cast that net too widely, this would seem to do the job.
Mm. Okay. Just coming back to Ms. Tiaho's point, I still don't think we need to specify them in the P5 rules. They're referred to where the rubber hits the road, no pun intended. So I don't think we need them in the rules. Because they're covered in the performance standards and the traffic standards.
Yeah.
All right, so where are we at? Leaving aside the consistency check, just Mr. McLaughlin, just remind me, you're saying that there's nothing about the versions that we've had prior to lunch that you now need to amend, correct? It's disappeared.
Apologies, I've done it again. Paula, do you have anything to add on section 127?
Yeah, I do. And just looking at that variation, unfortunately, I was given a little bit of wrong information, but basically what we're after is that an exception for the V8 supercars event.
What are you referring us to? What do you mean by 127? You mean the restricted?
We're referring back to the noise rule.
Yeah.
And as part of the variation, what it did do was provided an exception in any year where there was a V8 supercars event not being held. And what it did do is that it provided for up to 30 days per year where you could have 65 dBA at an L10 level. And the existing rule allows for 27 days. So basically it gives an additional 3 days per year.
Isn't that what the blue writing does?
Yes, it does. Yes, it does. I missed that, sorry.
Okay.
Yeah.
We're good. Good to go.
So to confirm and clarify, subject to a consistency check in the use of language, the version that is on the screen, subject to deleting those medium definitions from Rule P5 and Rule C1, because they are still in this chapter, but they're just not in that place. Are the parties on the call all satisfied that that's something that they sign off on?
Yes.
The transport agency is happy to sign off on that.
Thank you, Mr. Wood.
Same as Hampton Downs, sir.
Well, that's great. That was worth coming back after lunch for, I think. The thought that I have, and I haven't discussed this with the panel because we haven't had the opportunity to do so, but it seems to me that what we should do now is I don't think the panel specifically wants to do or needs to do anything other than suggest the following. And this is open for anybody to comment on, panel included, is that we ask Ms. Major to produce a clean version of the provisions that includes a consistency check, and that somehow or other she identifies on that version where she's made changes and for what reason. So there might be a little memorandum or something that accompanies it. I think we want to avoid redlining on top of redlining on top of redlining. It's just too hard to read. So we get a clean version of the provisions that she circulates to everybody, together with an explanation of what she's changed and why. That goes to all the parties that are the subject of this hearing. We need to figure out whether there's any other parties it needs, any other submitters it needs to go to. We can have a conversation around that. And then once that's been done, the parties would liaise to make sure that they're all happy with it, and then you would issue a joint memorandum back to the panel saying, following the conclusion of the hearing, we have gone away, checked consistency, and here are the versions of chapters 9 and 26 that relate to Hampton Downs that NZTA, the council, and Hampton Downs wish to see included in the plan. That way we get a bit of paper that records your position. We don't have to get involved in issuing minutes and stuff. And that would seem to be neat and tidy and address the issue often. That can be made public, put on the website, and anyone that wants to have a look at it can. What does the panel think about that as a start?
Just Phil, I'm agreeing with a whole lot of it. It's going to be like this has been a decision-making process today, and we can now walk away from the Hampton Downs hearing once this is all complete. They have said consistently that we will not be releasing any decisions until the final plan had been done, and which could be another 18 months away. So we just need to keep this under wrap until then. I mean, we can't announce one and then expect somebody else to wait. So
I think the purpose of this, no, we won't, that's why we're not issuing anything. The parties would be coming back to us with a memorandum saying that the council, Hampton Downs folk, and NZTA have, since the conclusion of the hearing, have liaised on the provisions, and the provisions that are attached to this memorandum are the provisions that they have settled upon and are asking us to include. So we wouldn't be making any decision on it. We'd simply be receiving it, but the parties would have signed up to it, as it were. So, which effectively makes it a done deal.
Yeah.
But we don't have to do anything. That's why I thought that was neater than us issuing any minutes or anything.
Yeah, no, that's okay. Happy with that.
What do the rest of the panel think? Ms. Te Aho, Mr. Cooney?
Yeah, I like that approach, and I'm fully supportive.
No, I completely agree with that. So just to clarify what Ms. Major does, Mr. Chair, what she's to go away.
I was suggesting that rather than a whole lot of committees, it becomes tedious. And I think as the reporting officer, having heard this is effectively the substitute for a reply type comment, having heard all the things that have been talked about. So I think it's appropriate for the council to do that rather than any of the other parties with a more vested interest, if you like, in the outcome. For Ms. Major to go through, accept all the changes that have been agreed, check for consistency to make sure when, if it says adjoining site in one policy, it says the same word in another one, those sorts of consistency issues.
Yeah.
She provides that to everybody else. They then get their heads together, and then they issue us with a memorandum of the sort that I just talked about.
Yeah. Yeah. And her memorandum would simply back to us record any further changes that have been made by agreement.
I think there'd be a memorandum of all the parties. I would prefer to see the three parties sign up to it that actually says, the fact that Ms. Major prepares the first version's not really here nor there. What is here or there is that we get a document that the three parties have a signature on a bit of paper saying, please incorporate these provisions because we've agreed them.
Yeah. Yeah. Okay.
Does that find favour with you?
Me, yeah.
Yeah. What do the parties think about that?
Yeah, I'm generally supportive of that approach. The one spanner in the works could be the consequential amendments that come through hearing 25, and I know that Mr. White for the Reed Trust was interested in getting some consequential amendments through the zone extent, and so it would just be subject to consequential amendments as a result of other hearings as all.
Well, we're only this hearing is only dealing with the notified zones, including their extent. If he wants to make an adjustment to something that relates to a new area, we'll just consider that when it arises. And even if it did, we're not bound, and none of the other parties are bound to what they've agreed to for this specific set of properties. So I'm more than happy if you want to circulate it to him, but I'm sort of thinking that he hasn't been at the hearing. He's an interested party, obviously, but not in relation to what you folk agree, but more in relation to what he wants to do on his property. And I think the neatest way is simply to say the parties that were at the hearing, being Council, Hampton Downs and NZTA, have filed a joint memorandum about what they want. And the more parties that are party to it, the more chance it's got of going off the rails, given that we've spent all day, constructively getting a set of provisions that everyone on the call is happy with. And I wouldn't want to unwind that.
Yeah, absolutely.
So I think he will get his chance at some point to say whatever he wants. This document, your minute, will be made available, on the website. We can think about it. Ms. Kelly may even distribute it to all the submitters on this hearing. That's probably not an inappropriate thing to do. But all it is a document from you three setting out where you've got to. So I think that's pretty safe. The only thing that
you go on.
No, you go, Paul.
The Mary Dragway are saying we want similar provisions to apply to us, as I understand it.
Yes.
But that's a matter we can look at in the zone extent.
That's a rezoning here, and the same with Mr. Reed. I think anybody else that says, well, we want our own motorsport park provisions the same as Hampton Downs, we can address that.
Yeah.
When and if they raise it.
Yeah.
I suppose the only thing that we will growl about is if we're getting any more changes other than consistency ones, because as far as at least I'm concerned, we've drawn a line under that. That's why we've spent 3 hours last week or 2 hours last week and about 4 or 5 today getting to the point that the parties are happy. So I think that would be, I'm going to say prohibited activity, but I don't think we can probably quite direct that. But we wouldn't be pleased to see any rehash of where people have got to today.
We'd be disappointed.
We'd be very disappointed.
Just before we move on, where did we finish up with your opening remarks, Mr. Chair, about P5? Remember, you were looking for a more generic approach instead of having minor event, medium event, major event spelt out. Where do we finish up with that?
I had thought, Ms. Tiaho raised the point, and I don't know if she agrees or not, but I think the reference to those bullet points don't need to be there, because the matters of the permitted activity rules, the traffic management rules and the noise rules pick up the definitional part as needed. So they don't need to, so simple answer is to delete them from the rule completely.
Okay.
And just say motorsport and recreation events are a permitted activity, subject to what's in that right-hand column. Then there's the noise standard and the traffic management standard that sits behind that they both need to comply with.
And that's the definition in chapter 13 under the broader heading motorsport and recreation events.
I haven't gone back and double checked that. I've taken Ms. Ratt at her word.
If you look at, well, if you look at chapter 13, may as well do it now.
Yeah.
Make sure we're right.
No, that's a good idea.
So if you go back to chapter 13 and it sets out there the different categories.
Just give me a second. I've just got to bring it up on my screen.
So I think Commissioner Tiahu is right in what she says. And
Yes. Hold on, I'm just navigating my way through the website. Modified version chapters. Chapter 13, definitions. Okay, I've got it open. Does it come under minor activities or does it come under motorsport?
It comes under motorsport and recreation events.
Right, okay. Motors, yeah, okay. I think the only thing is, one thing is that those definitions need to have the per day provisions added to them, because they don't at the moment. So that's maybe one of the consistency things, that leaving aside everything else can be pointed out. So I think, Ms. Major, if you can include the definitions, given that they are there, and if they need amendment, which I think they do, then you can put that in. Does that make sense?
Yep.
Okay.
To be clear, it's just the motorsport and recreation events that we're going to keep in the definitions chapter, because there's quite a few defined terms that are only specific to Hampton Downs that I've kind of pulled. I had originally recommended to pull from the definitions chapter and have within the rules themselves.
The ones that relate to the only other ones that are there are, I think, is the one that says motorsport and recreation facilities. And isn't that the same set of the same list that's in the other? It's been moved into the rules, hasn't it?
Yeah, correct.
So that definition can go. The second definition, the one relating to facilities.
Yes. There's also one day-to-day activity and other ones that relate to precinct.
Oh, is there?
So I've recommended that they all be removed from the definition.
Where's the day-to-day one? Is that under a different heading?
Yes, it is. Day-to-day. I think it's under A.
It's under D.
Oh, it is D, is it?
Under D for day.
Mm.
Well, I think we can leave. I think that that's a drafting thing that you can pick up in the consistency thing. And if we ended up, I think that's easy enough. But what's your point, Mr. Cooney? Sorry, these definitions are here. So doesn't that mean that when we refer to a motorsport and recreation event, we don't need to list these things in Rule P5 because they're already here?
Yeah. That's my question was to make sure we check it and make sure there's consistency there with the definitions. And
oh, I'm sorry. I see. Yeah, totally agree. And I think they aren't consistent at the moment because the suggestions that have been rolled into P5 had a few things like clarifying that they were per day vehicle numbers.
Yeah.
So, but they relate to the same. I mean, that's just a consistency check now, I think, isn't it?
Yeah, it is.
Are you happy with that, Ms. Tiahu?
Yeah. I just thought that, when you were talking about where to move those definitions, they were already in the definitions chapter.
Oh, sorry, I misunderstood what you were saying. Okay,
Yeah,
no, that's perfect.
That was the issue. And now as we flick through the definitions chapter, I see what the reporting officer's done. She's taken some of those definitions from the definitions chapter and just brought them into the Hampton Downs chapter so that you don't have to go back and forwards, but
Yes.
not all of them. And I think that's possibly the issue, that not all of those definitions that relate to the Hamptons specifically have been brought into that chapter. So I think you've got to do like one or the other.
I think what will happen though, where we do have a definition, this will be an E-plan. So there'll be a link on where it says motorsport and recreation event. It'll be highlighted with an underline or something that says there's a definition in the definition section. That seems to be the way that it's done. So I think we're okay.
So where does motorsport and recreation facilities come into the precincts, you know, as to what's permitted and what's not?
The facilities part are not permitted, I don't think. I think they're in the, unless they're specifically listed, a subset is specifically listed, they're in those controlled activity rules.
They're also a permitted activity within precinct A.
Oh, and in precinct A, sorry, yeah, quite right, sorry.
Okay.
I'm quite happy that we can leave it to the parties to figure out if there's a consistency issue, whether they're all in, all out, part in, part out, as long as it works, and as long as they are consistent. So,
yeah.
And if in the event that for other consistency reasons with other bits of the plan, we tweaked it and moved something from one section to another, I don't think anyone's going to care about that. I think the main thing is to get the words on the bit of paper that everyone's happy with, given where we're at the moment.
Yeah, I'm happy with that.
What I think all we need to get a clear view on is just what the time frame from here is. We're not under particular time pressure at our end, but we would like to keep the pressure on you guys so that this just doesn't drag on and it gets dealt with while it's sort of topical. What do you think your time frame is, Ms. Major, to get the party something?
Oh, I could get that, circulate that out by the end of next week, even earlier probably.
Let's talk about the earlier possibly part if we can.
Yeah,
Monday's a holiday obviously, and so is tomorrow. What are you thinking? Is it a couple of days? How about Wednesday, end of Wednesday, or maybe end of Thursday?
End of Wednesday sounds good.
That's not putting too much pressure on you?
No, I think that'll be fine.
A little bit's okay, but not too much. And if we get that, and then if the parties, how long do the parties think they need to check and cross-reference and go back around the traps to get a final document and a memorandum?
For us, the following day, I imagine. I don't think it's a big piece.
I'm liking the sound of that. No pressure, Mr. McLaughlin.
I might want more flexibility than that. Can we say 5 working days?
Yeah, I think because at the end of the day, there are 3-way conversations to be had. What we don't want to do is get another version with comments and margins and stuff. This is it. This is the final version. So if you've got any things you need to, check whether you think adjoining's the right or wrong word or whatever it is, you need to sort it out because we don't want to hear about it anymore.
Yeah, I think 5 working days would be sufficient for us to do that. I think we've walked through them in detail already. Okay,
and I think that's appropriate. So if Ms. Major will get something by close of play next Wednesday. If she's got a problem with that time frame, we're more than happy to get a note from you saying that you're late. Because it's got to be done properly rather than quickly. And then the parties, including Ms. Major again, will have 5 days from then to provide us with a memorandum and a clean set of provisions.
Mm.
Does that sound okay?
Yeah, that works for us.
is someone going to, I mean, we'll leave it to you to figure out who's going to write the memorandum and organise that, but that might be a job for the Hampton Downs folk, given that they've got more skin in that game than anyone else, probably.
Yeah, we don't mind doing that. It's, yeah, we just need to get it done.
Yeah.
Priority at this point.
Okay. Well, I think we're probably at the conclusion of what we need to do today, aren't we? Is there anything else anyone needs to raise or add?
No.
I suppose the one thing is for Ms. Kelly to circulate that those 2 documents that we've been working on today, just so that everyone's got the same version that we have been talking about.
Sure.
And I don't think that needs to go to everybody on the call. I think that can go to the representatives and they can figure out who to send it to. So if that goes to Mr. Wood, Mr. McLaughlin and Ms. Major, they can then circulate it amongst their respective people as they feel the need to.
Sure.
Thank you. That'd be good. All right. Is there anything else from the panel?
No, I'd just like to say, especially to NZTA for a positive contribution to this topic. It's been good actually to be able to work through the issues. Thank you.
Thank you.
Yeah, I just want to thank everybody. I mean, these are difficult times in some respects, and I think there's a few people. There's a few lawyers around town that have said that they couldn't possibly contribute to a hearing by video conference because it's far more important that they be able to stand up and address us in person and so forth. And I think to
be seen to be earning their money.
To be seen to be earning their money, yeah. And I think I don't know how you folk have found this, but it's not quite the same as being in the same room, but it's not much different. And we're just grateful for everybody's willingness to participate in the constructive way in which we've got to where we've got. So unless anyone wants to add anything to anything, where we can adjourn and leave you guys to go away and get cracking on our final version.
If I could just make a comment as a member of the panel, I know this hearing's been certainly different, but I think what's happened here today has been an excellent outcome. Certainly I haven't been able to contribute very much and haven't had any need to, because it's been very, very much a technical and a legal framework that we worked through. But I think to get a result like we have is very, very good result. Very happy about it. Thank you.
Great. Well, I think the panel would endorse that across the board.
Yeah.
So, all right. Thank you, everybody. We'll adjourn now, and we'll look forward to hearing from you in next Wednesday, plus 5 working days thereafter. Thank you all very much for your contributions.
Thank you.
Thank you.
Thank you all. Cheers.
You will.
Bye.